all persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 19-3060, United States of America versus Rodney Davis, appellant. Ms. Ernest for the appellant, Mr. Mcgovern for the appellee.
Good morning. Good morning, Your Honors. I will reserve 3 minutes of my time. May it please the court. My name is Robin Ernest and I represent appellant Rodney Davis in this appeal. Ms. Davis appeals her plea and sentencing from a single conviction of traveling to engage in sex with a minor on grounds of ineffectiveness.
I'm sorry, I'm having a little trouble hearing you. Could you pull the microphone a little bit closer?
Certainly, Your Honor. Is this better? I can also stand closer. Thank you. She appeals her plea and sentencing from a single conviction of traveling to engage with sex with a minor on grounds of ineffective assistance of counsel. Specifically, she claims counsel was deficient in advising her to agree to an incorrect statement of law in her plea. That statement was that 4 additional offense level enhancements applied to her sentence under Section 2A3.1b for offenses that involved a minor. To the contrary, the section's plain language, its enhancements applied only to offenses involving victims. Its text does not even include the word minor, and victim and minor are defined differently. But what Ms. Davis knew, and what the record reflects, was that her offense did not involve an actual victim. In contrast, because the guidelines define minor to include a fictitious individual under age 18, Ms. Davis knew her offense involved a minor, and since minor was the term used in the plea agreement, she signed the agreement. Thus, Davis presents a colorable argument before this court that counsel advised, had counsel advised her that the plain language reading of Section 2A enhancements applied only to victims, not minors, as her agreement read, she would not have agreed to 4 additional enhancements for her victimless offense. And because the record does not allow this court to conclusively determine that Ms. Davis would have agreed to textually inapplicable enhancements in her plea, remand for an IAC hearing is warranted under U.S. versus Rashad. Ms. Davis
saw the pre-sentencing recommendation, pre-sentencing report that, I'll do this. She saw the pre-sentence report, and that included recommendation of the enhancement and made no objections to that. So that seems in tension with your argument that she was under the impression that she would not have such an enhancement.
So she did not see the pre-sentencing report until after she signed her plea and had her plea hearing.
I know, but she could have raised an objection at the sentencing hearing and said, I didn't know this was going to happen, but did not.
Sorry, Your Honor, for the interruption. Relying on her counsel to object or to not object to legal errors, her counsel, that is correct. He did not object to the court's extra text insertion of fictitious into the plain text of Section 2A in order to force the 4 additional enhancements.
Did she speak at sentencing?
She only spoke in sentencing and allocution, so after everything had been done.
But she had an opportunity at that point to say, wait a minute.
That if she had known, Your Honor, if she had, since the time of arrest, she had been detained in the DC jail. She was in solitary confinement because that was the treatment at the time for transgender individuals. She did not have access to the guidelines in order to compare the language in her plea with the language in the guidelines in order to be able to determine that, in fact, the plea agreement misstated the guidelines, that the guidelines, in fact, did not apply to offenses involving a minor, which, of course, was her offense. She was smart enough to know that if the plea agreement had, in fact, said that the enhancements applied to offenses involving a victim, she knew that hers was a victimless offense. So she would have.
What if she had at this meeting encountered not a fictitious child, but in fact a super young looking police officer, and then had gotten that super young looking police officer that she thought was a teenage child. I know 8 years old probably isn't going to work. Let's just say it's a minor nonetheless, and transported that police officer across state lines for purposes of sexual misconduct. Would there be a victim in that case?
So that actually is under a different provision of the guidelines, but the way the guidelines define victim, it does include an undercover officer. So if the undercover officer had been posing as... But
your textual arguments about victim involving actual crime, this is the arguments in your brief, actual harm, physical injury, those types of things would apply just the same. It's the police officer is just as fictional a victim as the non-corporeal victim in this case?
Except for the fact that the commentary for the offense guidelines under Section 2A expressly define an undercover officer who is posing as someone who is underage to actually include a victim. So under your hypothetical, yes, that would be a victim.
So it seems clear that the Sentencing Commission wanted to capture fictional victims, at least if they are police officers. Why would they want to include that fictional victim, but not the type of fictional victim we have here? Because in both cases, there would be no actual, the charged conduct would not actually happen.
Because in 2004, Your Honor, the commission expressly removed that type of travel offense from out of sentencing under Section 2A and provided a lower base offense level for it and provided a separate definition of minor. Minor includes a fictitious individual being offered by an undercover agent for sexual services, but it also can include an undercover officer who themselves is posing as an underage individual being offered for sex. So under the plain text structure of the travel offense guidelines, I will call them, it's actually Section 2G, it allows for the hypothetical, Your Honor, that you expressly identified. And that would be when there is a victim in a undercover officer posing as an underage child or an actual underage child, then that would be sentenced more severely under the cross-reference section of 2A 3.1C, which was employed here. But because that's not the facts of this case, in fact, the undercover officer, the court did identify that in other cases, there had been an undercover officer had posed as an underage child. And in those cases, they were sentenced under the 2A 3.1B enhancement sections identified here.
Given that, if I recall correctly, at least two other circuits have rejected this very argument. How was it, and we have not yet spoken. How was it, explain to me how that can meet the Strickland standard, given that the very argument has been rejected in other courts?
The circuits that were identified by Apelli, the cases that were identified by Kelly, which took a extra textual interpretation, were cases which were adjudicating a sentence prior to the 2004 amendment. So there was not the new travel offense guidelines had not been created. So at that time, the only route for sentencing a travel offense, which is what Ms. Davis was convicted of, was through Section 2A. So what they did in those cases was they looked to the intent of That section deals mainly with it's titled sex abuse and attempted sex abuse. So those cases look to the general intent of those guidelines, which was, they felt, to punish sex abuse and attempted sex abuse the same. And that's one of the reasons for that the commission in 2004 moved out travel offenses, because in those instances, you don't necessarily have an actual victim. You have and use the definition of minor, which is what Ms. Davis was convicted of, traveling for illicit sex with a minor as defined differently from victim. So because there is this unclear language in the plea agreement that she read, that she thinks now the enhancements are applicable to her case because it uses the language minor as opposed to the actual language in the guidelines, which is victim, she signs the plea agreement. She's not told otherwise, and her counsel doesn't object to the extra text reading of fictitious into the exact guideline language in order to force application of the enhancements under Section 2A, which would not otherwise be applicable because they only deal with victims. And if I can just answer your sort of out-of-circuit question, if I could expand upon that, Your Honor.
Very quickly, because you're over your time.
Thank you, Your Honor. The cases of U.S. versus Winstead and U.S. versus Glover from this court both have said that for outer circuit cases that take an interpretation of a statute or guidelines that's contrary to the plain text, that this court is not bound by the reasoning, and especially in instances where, as here, appellee does not address the textualist argument as to why it on itself would be wrong, then they are not inclined, and in U.S. versus Winstead did not accept as controlling the out-of-circuit cases.
Okay. Unless my colleagues have any questions? All right. Thank you very much. We'll hear from the government now.
Thank you.
Good morning. May it please the court, Michael Mcgovern on behalf of appellee of the United States. Appellant's sentence should be affirmed because her counsel did not perform deficiently when he took the position that a 4-point sentencing enhancement applied given that the child appellant believed she was traveling across state lines to sexually abuse was only 8 years old. With respect to the ineffective assistance claim, although appellant presents an issue of statutory interpretation that has yet to be decided by this circuit, the question before this court today is not whether it would adopt appellant's interpretation, but whether defense counsel's failure to adopt that interpretation at the time of appellant's plea fell below the wide range of reasonable professional assistance or competence demanded of attorneys in criminal cases. It did not. It was not obvious from the plain text of Guidelines 2A 3.1 that the undefined term victim excludes virtual victims that are not real children. In fact, far from being obvious at the time of appellant's plea, 3 circuits, the 6th Circuit, the 10th Circuit, and the 11th Circuit, had rejected appellant's arguments. Those circuits looked to the fact—
What's your answer to sort of the plain text argument that victim means a real person in any sort of ordinary use of that term, and actually under the guidelines, they describe things like 2A 3.1b4 if the victim sustained permanent or life-threatening injury. There's repeated references throughout there to things that could only happen to an actual person. So how do you reconcile guidelines in that sense?
Well, Your Honor, to the extent that the guidelines involve certain enhancements that could only apply to real or live victims, those couldn't possibly be applicable to a virtual victim. But those guidelines similarly would be inapplicable to victims of attempt crimes. And these guidelines were intended to provide the enhancements that were applicable not only to completed crimes, but also to...
So is there a different meaning for victim for attempt crimes rather than completed crimes?
Your Honor,
it just shows up as one word in the
Your Honor,
guidelines. I think we have to give it a single meaning.
Yes, Your Honor. The government's contention is that the meaning of victim is the object of one's criminal conduct. And here, the object of the criminal conduct of Ms. Davis was the virtual victim that was created by the law enforcement officer. And that definition would apply to permit the enhancements to be applied to attempt crimes as well as to completed crimes, which was clearly in the intent of the Sentencing Commission. And the term victim, the definition that appellant has proposed, that one has to suffer harm, would exclude any type of enhancement for a victim to apply to any attempt crime, which is very clearly, as the title of the section not was provided.
Are there other places in the guidelines, you're more familiar with them than I am, that use victim to refer to fictional victims? Or is this the only place?
Well, Your Honor, I will note that in, and this is discussed in the 6th, 11th Circuit cases that we cite in our brief, that the term victim was expansively defined in Guideline 2A3.2. This was at a time prior to the 2004 amendments. And at that time, in the 2000 amendments to that particular guideline, the Commission defined victim expansively to include, as Your Honor noted when speaking with Appellant's Counsel, undercover officers posing as underage individuals. Those individuals are not real underage individuals. Rather, they're fictitious individuals. And the Commission was clear that the reason that it was doing this, and I'll quote from the language, the amendment adds several definitions, including clarifying that victim includes an undercover police officer who represents to the perpetrator of the offense that the officer was under the age of 16. This change was made to ensure that offenders who are apprehended in an undercover operation are appropriately punished. And so their amendment, which clarified, and they referred to it as a clarification, clarified that victim's definition should include undercover police officers posing as underage individuals, was to make sure to clarify that they intended to punish those caught in sting operations, which did not involve actual children.
Are there other places in the guidelines that use this term victim in this expansive way?
Your Honor, I'm not familiar enough to answer that question authoritatively. But I will note that one of the points that appellant makes is that the term victim would be absurd if it were to be included for the enhancement that a victim was abducted. But in fact, because these guidelines are punishing the intent of the individual, and they're meant to punish the culpability for one's criminal intent rather than the effect of their criminal conduct, if the undercover represents, I have abducted a child.
Well, not just intent, I mean actions to effectuate that intent as well.
Correct.
It's punishing the combination of intent and actions taken to someone could sit in their room and intend to do something. But what happened here is you had an intent and then steps were taken to effectuate that intent as well.
That's correct, Your Honor. But as the 6th and 11th Circuits noted, the purpose behind these particular enhancements, the reason these enhancements are adding time to the criminal punishment is because they are intending to punish the intent of the actor towards the individual's age, not the conduct. And again, they point to the fact that inchoate crimes are punished in the same way that committed crimes are here. And when that's the case, when they're intending to punish them in the same way, it's because they are focused on the intent of the actor, that the criminal culpability arises from the actor's intent.
Do the guidelines use the word victim for other inchoate crimes as well?
I'm not sure that I can answer that authoritatively, Your Honor. I apologize.
A defendant traveled across state lines with the intent to have sex with a minor, but didn't have a specific minor in mind. Would that violate 2423B?
question is if the actor traveled with an intent to engage in a sex act with an individual.
I can try to give a more specific hypothetical. Imagine someone lives in DC, writes in a diary, I'm going across state lines in order to find children to have sex with, and then crosses state lines, and then writes in the diary, I've now crossed the state line in order to have sex with children. But that person doesn't have a specific child in mind. Is that a violation of 2423?
Your Honor, I believe that it would be. I believe that it would meet the elements. I haven't specifically looked at that issue, whether there would need to be a specific object of the sexual abuse. But I believe that if the intent element were met and the travel actus reus element were met, that yes, that would meet the definition.
What about imagine, well, that's okay.
I see that
I had a quick question about the appeal waiver in this case.
Yes, Your Honor.
The district court did not detail its terms at all, but in fact, even worse, at sentencing, described the context in which the appeal waiver would not apply, but didn't describe all of them. At transcript 143. Why is that not a serious problem for an appeal waiver to discuss a couple exceptions, but not all of them?
So I apologize, Your Honor. You referred to the transcript at
143, the sentencing transcript at 143? I think it may be JA 143.
Well, Your Honor, as an initial matter, I would note that any misdescription at sentencing wouldn't necessarily affect the validity of appeal waiver that was entered into knowingly, intelligently, and voluntarily during the plea hearing. And during the plea hearing, there was not a misdescription.
Well, the pleas can still be withdrawn or clarified at sentencing, right? The terms of it? What if you said, wait a minute, I didn't realize that? Before final judgment is entered? No judgment's been entered yet on this plea at this stage. Anyway, I don't want to debate that issue. What I want to know is, let's assume that I'm right, that at least the district court would have the discretion and maybe the duty to revisit the voluntariness of a plea if it's raised prior to entry of judgment. And the district court misdescribes the scope of the appeal waiver. Is that a valid appeal waiver?
Certainly, if the district court misdescribes an appeal waiver at the time that the appeal waiver is being entered, this court has found that the appeal waiver is only effective insofar as the court correctly described it, or insofar as the court described it. And so an appeal waiver that had misdescribed the contents.
Well, we have a situation where the district court didn't discuss the terms of it during the plea hearing, didn't discuss at all other than the existence of an appeal waiver, and then its sentencing misdescribes its scope.
I have not seen this court address a situation where that's occurred.
That's why I'm asking you the question. If I knew our answer, I wouldn't need to.
But again, I would point to Lee, and in the Lee case, they specifically note that there was no description of the plea waiver at the plea hearing. And I believe, I could be misremembering the case, but I believe there were statements in Lee which indicated that even a misdescription at the sentencing hearing wouldn't be relevant because the applicable time for determining the knowing and voluntary and intelligentness of the plea waiver would be at the time it was entered into.
The problem is whether district courts can confuse defendants before final judgment is entered on that plea, right? No judgment has been entered on that plea. No final judgment. Correct.
No judgment has been entered at that point, right, Your Honor, until following the sentencing hearing.
Right. It would seem to me worse when a district court confuses. It's either you don't describe it at all, or describe it accurately, but misdescribing it seems to be the worst of all options, correct? mean, that's the worst of all those options.
Well, Your Honor, what I would note is
Right,
that...
that's the worst of the three options. Don't describe, accurately describe, and misdescribe?
Yes, Your Honor, misdescription would certainly be worse than failing to describe or accurately describing.
Mm-hmm.
But in this case, we didn't just have what happened at the plea hearing. We had an allocution with the appellant in which appellant admitted that they had discussed this plea agreement and all of its relevant provisions with their counsel. This was an appellant who had gone through and gotten a master's, was the court found of high intelligence. And so there's no reason to believe on this record, and certainly not that appellant has pointed out that the appellant was confused about the terms of the plea waiver. The sole argument appellant has made on appeal is that the plea waiver should not be valid because there was ineffective assistance of counsel with respect to the application of the enhancement guideline. And as we've argued, there was no ineffective assistance of counsel, and that didn't vitiate the plea waiver or the validity of it.
And can you just tell me, because is it standard practice for district courts just to incorporate the standard terms of supervised release by reference, or I don't know what the common practice is?
Your Honor, I also similarly, as I stand here today, am not aware of the common practice of whether they typically detail them or reference them by reference.
Have you been involved in other cases where they were not detailed like this?
Not that I can't specifically recall. I don't know that I was focused on that issue in any of the other cases when I was reading the transcripts of various sentencing hearings that I have.
More questions?
Unless the court has any further questions,
Thank
we
you.
respectfully request that you affirm the sentence.
Ms. Ernest, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. And may it please the court, I just wanted to address more directly some of the questions that your court presented.
You may need to readjust the microphone again. I think my hearing's getting worse with it.
No, it's me. I'm sorry. Judge Walker, you asked the question whether or not victim was defined differently any place else in the guidelines. I do not know directly, but I do know that the travel offense guidelines under 2G do not even use the term victim. They use the term minor, and they do provide for an enhancement for offenses like Ms. Davis that allow for an additional 8-point enhancement for offenses involving a minor under the age of 12, like Ms. Davis's. Also, Judge Millett, you asked about the appeal waiver. In U.S. versus Gullen, the Justice Ginsburg, writing for the court, emphasized the importance of the court because these waivers are pre-sentencing, they're anticipatory of the court, in fact, going through the appeal waiver in Rule 11N and distinguishing Lee. In that instance, when the court did not, then 2 things. The court said that the plea agreement was crystal clear, and here we are presenting a colorable argument for ineffective assistance of counsel because the plea misstated law, which Ms. Davis relied upon in relation to the enhancements, and her counsel did not correct. And in those instances, then under both Lee and under Gullen, this court has refused to enforce an appeal waiver in a plea. I see my time is about to expire. Are there any other questions?
Ms. Ernest, you were appointed by this court to represent Ms. Davis in this appeal, and we are grateful to you for your assistance.
Thank you very much. Thank you for your time.
Case is submitted.
Case number 20-7111, Xingru Lin, appellant, versus District of Columbia, et al. Ms. Dennis for the appellant, Ms. Trayer for the appellees.
Good morning, and may it please the court. My name is Kelsey Dennis, and I am here on behalf of appellant Ms. Lin. I would like to reserve 3 minutes for rebuttal, please. Thank you. When the district court initially granted summary judgment in part and denied in part, it made 2 key rulings of law. First, that the police had probable cause to arrest Ms. Lin for simple assault. And second, that there was a genuine dispute of material fact as to whether probable cause existed for the arrest for assault on a police officer or APO. However, upon reconsideration, the district court completely abrogated its second ruling. Citing to Harris, the court held that it didn't matter whether there were disputes regarding the APO. Rather, because the court found that there was probable cause for the simple assault, Ms. Lin could no longer proceed on her claims of false arrest for the APO. That judgment upon reconsideration was an error of law for 2 reasons. First, probable cause for the simple assault had in fact dissipated in the period between the 2 arrests, and as a result, the probable cause from the first arrest could not be imputed onto the second. There was plenty of evidence in the record that probable cause had in fact dissipated, but the court did not weigh this evidence in the light most favorable to the non-moving party. Plaintiff only needs to establish that there is a genuine dispute of material fact as to whether probable cause existed for any charge at the time of the second arrest for APO. Second, because probable cause dissipated between the 2 handcuffings, Harris was not dispositive, and it was a mistake to consider it controlling for purposes of Rule 54B. The district court improperly used a non-dispositive decision to dispose of plaintiff's 3 remaining claims in its order on reconsideration. As such, the 3 remaining claims relating to Ms. Lin's February 15, 2016 false arrest for APO should survive summary judgment. While the Rule 54B standard of as justice requires may be flexible, justice does not require nor allow a court to violate the Rule 56 standard by weighing evidence in the light most favorable to the moving party. That is exactly what the court did in its order on reconsideration. For Harris to be controlling, there would need to be probable cause for the simple assault at the time of the second arrest. The district court itself defined probable cause as a reasonable conclusion drawn from the totality of the circumstances. Probable cause cannot be established where there are materially impeaching circumstances or when the information provided to the officers is not credible. The court did not consider this totality of the circumstances in the record here. In its order on reconsideration at page 6, the court stated that plaintiff provided no support for the speculation that probable cause had dissipated. Respectfully, that is not correct.
You know, you talk about the first arrest for simple assault, but Officer Johnson said it wasn't an arrest. It was simply a Terry stop, that this person was the one that they thought was the aggressor based on a discussion outside with an alleged victim. And to get more information, they were just handcuffing this person while collecting more information. So I was curious about why your argument seemed to assume that there was actually an arrest, because for a Terry stop, they wouldn't even need probable cause. They just need reasonable suspicion. So we don't know the probable cause the officers even thought, or reasonable officers would have thought there was probable cause at any point to arrest her for simple assault.
It is absolutely correct that at the summary judgment stage, the argument amongst the parties spoke to whether or not that first arrest for the simple assault was an arrest or merely a detention, as you speak of. However, both parties agreed that there were 2 events in question here, one for the simple assault and one for the APO.
And maybe 2 events, but for the argument that the probable cause for the first one supported the arrest at the later time, it seems to confuse things to talk about that under the assumption that there was probable cause when it was described by the police officers themselves as just a Terry stop, and the handcuffing was just simply part of effectuating officer safety. Does that matter?
Well, in the judgment on summary judgment, the order on summary judgment, the court determined that it need not resolve this specific dispute that you're speaking to because the court itself found on summary judgment that there was probable cause for that first event. And as such, on reconsideration, held that that probable cause carried over and disposed of plaintiff's 3 remaining claims relating to her false arrest claims for the APO. However, what is crucial here today and the error of law that we draw your attention to is that the district court did not properly consider the totality of the circumstances as to whether that probable cause that the district court itself found on summary judgment dissipated in the period between the 2 handcuffings, which I was referring to as the 2 arrests.
And is dissipation a jury question or a question of law?
We believe that the district court improperly disposed of information that should have been left to the jury. The district court found that there was no dispute of material fact as to whether probable cause dissipated. However, the error of law that we draw your attention to today is that the court did not consider the totality of the circumstances in the light most favorable to the moving party, as is required by the Rule 56 standard. As I mentioned on page 6 of the reconsideration order, the court held that plaintiff provided no support for the speculation that probable cause dissipated. But the court did not consider the following 4 key pieces of evidence. First, the officers agreed that plaintiff should be cut loose and her handcuffs were removed. Ms. Lin's handcuffs were off and she was wandering around her place of business for approximately 10 minutes. Second, Ms. Rodriguez was deemed the aggressor and no longer a credible source of information. Third, other than Ms. Rodriguez's statements, there's no independent evidence of what occurred on the bus. Ms. Rodriguez's scratches just as easily could have come from the only physical altercation for which there is actually objective video evidence, the one in which she was in fact the aggressor outside of the ticketing station. And finally, Ms. Rodriguez was illegally on the bus, and therefore Ms. Lin had a right to remove her. Ms. Rodriguez did not have a ticket and was subsequently charged with unlawful entry into a motor vehicle. In fact, during Officer Merzig's deposition, he even recognized that Ms. Lin had a right to remove Ms. Rodriguez from the bus. In the court's order on reconsideration, it ignored this evidence that probable cause had dissipated between the 2 handcuffings and thus could not be imputed onto the second arrest for APO. This is improperly weighing evidence and making inferences in favor of the moving party, contrary to the mandate of Rule 56. Upon reconsideration, the court did do its own analysis of the video evidence to determine if probable cause had dissipated.
Is it possible that, assuming Ms. Lin was the victim of the first assault, that would provide her a motive that would actually increase the probable cause that already exists when someone like Ms. Rodriguez has bruising and says, I was assaulted and I'm identifying by name, I'm identifying?
The critical question here is whether or not there is any dispute of material fact, a genuine dispute of material fact as to whether that probable cause dissipated. So what I would draw your attention to is that it is equally likely here that Ms. Rodriguez, who was the aggressor outside of the ticketing office, and there is objective evidence that she provided false information to police officers about the incident in question, also had a motive that would significantly decrease probable cause and even dissipate it. And again,
I understand that to a degree, but let me rephrase. Assume I think that in a different situation, all else being kind of unknown, there's probable cause to arrest someone who is accused of assault when the accuser is not anonymous and when the accuser has physical signs of it. And now my question to you is, assume there's probable cause there. Is there more probable cause or is there less cause? When we add to that knowledge, there had been a previous encounter where the accused may have been a victim and therefore might have a motive for the second assault.
So the incident in which Ms. Lin was attacked outside of the ticketing office actually came second, and therefore it would, in your hypothetical, she would have had to retroactively had.
Oh, that's okay. So the under your theory, Ms. Lin was, everyone agrees that Ms. Lin was the victim of second.
Understood.
I'm sorry.
Yes, no, that's completely okay. I just wanted to clarify for you. And I see that my time is coming to a close. So yes, of course.
If you could just explain to me what precisely your theory is of negligent supervision in this case.
Sure, of course. So as you discussed, one of the arguments made in our brief is with regards to negligent supervision. And I will try to be quite brief because I realize that I'm over time. And so
It's okay. Answer the question as you need
thank
to.
you very much. So in our brief, we discuss an error in granting summary judgment on plaintiff's negligent supervision and training claim because we believe that the court and argue that the court engaged in an incorrect application of DC v. Tulin, finding that Sergeant Ritchie's investigation of the APO could be distinguished from the lack of investigation in Tulin, which resulted in the court's finding of negligent supervision. However, in Tulin, the court held that defendant was liable for negligent supervision, not because there was no investigation, but rather because the investigation was not sufficient to identify critical information. So here, as in Tulin, there was negligent supervision based on the facts of the case. Sergeant Ritchie was aware that Ms. Lin was falsely arrested when he arrived on the scene, nonetheless went on to authorize another false arrest for APO after watching inconclusive video evidence of the incident. As the district court found in its opinion on summary judgment,
Sergeant Ritchie didn't watch video evidence of her. I know they were watching the video evidence of the fight out on the assault out on the street or the sidewalk by the bus. Did he watch video evidence of the arrest itself?
I can double check.
The handcuffing, I should say, itself.
When he initially requested that Ms. Lin be arrested for the APO, that is before he looked at any video evidence as to whether the APO actually occurred or whether he believed that there was probable cause. I believe that he subsequently looked at the video evidence from within the actual office, the bus station, after making the suggestion that she should be arrested for the APO. As the district
I'm
court,
sorry, does the record say they looked at the evidence, the video of the arrest itself before she was removed and taken to the police station?
I do not have a specific record site for that question at this time. I'm happy to gather one and bring it up.
That's your understanding of what happened?
That is my understanding of what happened.
Okay.
But as the district court found in its summary judgment decision, there was a genuine issue of material fact regarding whether probable cause existed for that APO because of the extreme lack of clarity in that surveillance video.
But to get to Judge Rao's question, is that necessarily the same as whether there was negligent supervision? Because you can see the sergeant talking to the police officers about the handcuffing process. And, there's sort of contradictory words coming out of people's mouths. Even if ultimately, assume there were not probable cause for arresting for assaulting a police officer, that doesn't necessarily mean there was negligent supervision in making a call on the scene based on sort of contradictory information.
I would draw your attention to two pieces of evidence that underscore the negligent supervision that occurred here. First is that the suggestion for the arrest for an APO was made before any of this sort of objective analysis of the video evidence was done. And second, the conversations that were had with the police officers led to significant uncertainty as to whether the officers subjectively themselves even believed that they had been, quote, APO'd. And so there was a lot of discussion around that with the officers. And while Sergeant Ritchie did that initial conversation with them, it remained highly unclear as to whether APO was appropriate based on even those subjective opinions.
I asked about, give you a chance to respond to the government's argument in its brief that two issues were not preserved at the district, or at least two halves of two issues were not preserved. One is, they say on count 7, negligent infliction of emotional distress, that the theory that there was infliction of emotional distress through excessive force was not preserved below. And then let me say the second one too, and you can respond to both. And then they say on the DCHRA claim that the disparate impact unintentional discrimination was not preserved. Below, they say it was not mentioned in the complaints and only briefly mentioned in opposition to a summary judgment. So if you could respond to that, I'd be great.
Yes, of course, and thank you for giving me that opportunity. So I will speak first to the negligent infliction of emotional distress, as you spoke. So in Ms. Lin's opposition to defendant's motion for summary judgment, she argues that officers failed to follow MPD's procedures for identifying limited English proficiency persons, which led to an unjustified use of force that placed Ms. Lin directly into danger. That's on page 44.
So is that's more than a theory that because of the language access issue, she should not have been handcuffed at all, arrested at all? That you're saying that goes beyond and says, even if it was okay to arrest her or handcuff her, that there was excessive force. Why is that? Why do you read that into that? I'm not opposed to it. It doesn't have a magic word, excessive force. So tell me why it accomplishes the same.
So here we argue that in plaintiff's opposition motion, she provided a detailed account of an instance where, for example, defendant Johnson yelled at her to turn around, grabbed her arm, and describes how the officer's unreasonable force was used to push Ms. Lin onto the ground when conducting the wrongful arrest. And as a result, she experienced extreme emotional consequences and physical consequences.
Is it enough for preservation purposes to mention it in the opposition to summary judgment motion and not in the complaint?
We believe that we fully preserved this argument on appeal and as well here in the opposition to motion for summary judgment. However, even if the panel does not find a reversible error of law in the original summary judgment order, at bottom, we ask that the September 30, 2020 memorandum order, which impermissibly dismissed plaintiff's 3 remaining claims relating to false arrest, be vacated. But I will also speak to your second question, which was with regards to the Title VI DCHRA unintentional discrimination claim. Is that correct?
Yes, please.
Okay. So as well, I will point your attention to, I believe it's the same page 44 on our opposition where, page 44 on our plaintiff's opposition to your motion for summary judgment, where we state that even if the court does not find intentional discrimination that violates Title VI, the DCHRA claim is not automatically defeated because DCHRA goes beyond to protect unintentional discrimination as well. Thank you very much.
I wasn't saying thank you, you're done. I was just saying thank you for answering my questions. It's up to Judge Millett to tell you if you're done.
All right, thank you very much. We'll give you some time for rebuttal.
Thank you very much.
And do we know where counsel for the government is? Oh, you're on the video. Sorry, I forgot. There's an empty chair over there. I apologize.
Good morning.
Sorry, I apologize, Mr. Ayer.
No worries. And the court is ready. Good morning. Thank you. May it please the court. Tylen Trayer for the appellees. There is an easy path to affirming the district court here, and that is to decide whether probable cause existed to arrest plaintiff for simple assault, in which case the existence of probable cause for that offense necessarily precludes plaintiff's false arrest claim based on APO. And it's abundantly clear from the record that probable cause existed based on the facts known to the officers at the time that they apprehended Ms. Lin, and that probable cause persisted, notwithstanding the video footage that showed a different altercation than what Ms. Rodriguez reported. And I know my friend on the other side spent much time emphasizing whether or not the district court properly took into consideration the totality of the circumstances. But it's very important to note that no facts came to light during the course of the investigation that would have called into question whether or not Ms. Lin actually assaulted Ms. Rodriguez on the bus. There was subsequent video footage of a different altercation.
What fact that the officers did not believe that the first handcuffing was in fact an arrest. Does that matter for your argument?
I don't think it matters, Your Honor. And probable cause existed independently for both offenses. And so if the court were to determine that one arrest occurred later in time, there's the existence of probable cause independently on the APO charge. As much as we argued initially that there was not even an arrest, we also argued below that, of course, probable cause existed to substantiate that arrest, and so it was not a false arrest. But I think for the court's purposes, again, the easiest way to undertake this analysis is to view the facts as viewed through the lens of the officers at the time that they encounter Ms. Rodriguez. We have an eyewitness account, a victim who, in this case, has a bleeding injury on her face and positively identifies her assailant, the assailant's location. And in those circumstances, under the Pendergrass and many other cases, that is sufficient to establish probable cause to arrest plaintiff at the time. And I just wanted to point out again that
not if it dissipates and you have the officers, when they look at the video, both of them, but clearly concluding that, is what we get. She was the aggressor, referring to Rodriguez. She was the aggressor. And they watch the incident on the bus itself, watch it and see what happens. And then they turn around and they talk about, not that there was another assault, they don't even mention anything. Like they go, should she be charged with illegal entry? Or, exactly what is the sort of technical charge for getting on the bus without a ticket? Now, if there had just been a brawl on the bus, they'd be talking about that. But we know that they said, based on the information in front of them, that, Rodriguez is the aggressor. And whatever happened on the bus made them only contemplate and think about charges for illegal entry. There's what in the record? And by the way, both of them just described a single incident. Neither of them said that there were two fights. They both described single incidents. And it's just that by the time they finished looking at the videos, Ms. Rodriguez's credibility had been completely shot to the point where they said, she's the aggressor. So what evidence do you have that there was another assault by Ms. Lin? What evidence did a reasonable officer have that there was even a fight on the bus itself in which Ms. Lin was the aggressor?
Yes, and several answers to your questions, Your Honor. First of all, I'll point the court to page 22 of plaintiff's brief, where plaintiff acknowledges that the footage was not of the assault on the bus. So I think by plaintiff's own acknowledgement there, in addition to Ms. Rodriguez's description, I think it's JA271.
Sorry, plaintiff's acknowledgement?
So I'm reading from plaintiff's brief at page 22, where plaintiff.
I asked what evidence is in the record that the police officers have. They didn't have her brief.
The evidence is, and my apologies, the evidence in the record would be the body camera, the body-worn camera footage from Officer Vullo, their conversation with Ms. Rodriguez, where she describes an altercation on the bus, and I think that's acknowledged and substantiated by plaintiff in her brief. But I think another point is that information gleaned from the video footage occurred after the fact, and the officers are still undertaking their investigation at that point. There are additional facts that come to light that need to be run down, but again, it's of a different altercation than what Ms. Rodriguez described, and that those after the fact, that information learned after the fact does not, again, call into question what the officers knew at the time that they initially apprehended plaintiff. And so that would be improperly according.
The closed circuit video of what happened on the bus itself in the record, because we don't have that.
No, Your Honor, no, but we have, again, the report from Ms. Rodriguez of the different altercation. And there's also what
the officers were looking at when they saw her get on the bus.
I'm
right?
sorry.
Inside the travel agency, they were looking at, it certainly looked like, at least where she was entering onto the bus. They said, there she is. Want to see what she does. And she got on. Whereas all we have is video of the officers watching a grainy video.
That's right. And so the video that they were viewing, I think, actually it may be, I'm sorry, JA 279. In the record, there's a video, I believe the camera is placed outside of the station. And so you can see the bus and the sidewalk outside of the station. So there's footage of what occurred on the sidewalk, but not inside the bus. But again, I think it's only fair to read plaintiff's brief as at the very least not disputing that there were two altercations that occurred. I'd also point the court to Officer Vullo's deposition in the record. I think that's around JA 541, where he describes that in making the arrest report and the ultimate simple assault charges against Ms. Lin, that he went back through the video footage and back through his notes and considered the fact that there were these two different altercations reported. And again, just to sort of take a step back, the probable cause inquiry is not a high bar. It's not the same thing as guilt beyond a reasonable doubt. The standard allows for facts and circumstances on both sides of the equation, but where there's a fair probability that here plaintiff assaulted Miss Rodriguez, where she's making that report, and again she has a bleeding injury on her face, and there's nothing in the video footage to call into question whether or not that assault occurred on the bus. The probable cause did persist throughout the entire time, such that
cause requires some evidence that this injury occurred on the bus. Some affirmative evidence.
We have the eyewitness.
The absence of evidence can't be sufficient. There has to be some affirmative evidence, and there can't be materially impeaching information.
That's right. And so my
affirmative at the time of the arrest, not the post hoc report, not going back at the time of the arrest, not going back and viewing things later in the station. At the time of the arrest, the positive affirmative information of a second assault was what?
The positive.
Because
I'm sorry, I may have missed.
Was it just Rodriguez's explanation?
Yes, and that is, it's her. I'm sorry. The affirmative evidence in the record is her eyewitness victim account, her bleeding injury on her face, and the
bleeding injury is fully covered by the video of the assault that she initiated outside. Then you see Ms. Lin swinging back. So I'm asking not whether before they saw the videos. I'm asking before they effectuated the arrest as opposed to the Terry stop. The affirmative evidence was you're sticking with the Ms. Rodriguez had a scratch and told a story, and that wasn't materially impeached.
Yes, and that's sufficient under the Pendergrass case. And my only point with respect to what I think Your Honor termed the absence of evidence later on is that plaintiff has asserted that materially impeaching circumstances arose later in time by virtue of the video. And my point there was that we don't have video evidence actually that would call into question that account of the assaults on the bus. But
you have video evidence that would support it?
That would, I'm sorry, I think I missed Your Honor.
It would support the assault. Again, other than we have her.
Right. Well,
distinct from Ms. Rodriguez's complaint outside when the police first arrived, which was pretty thoroughly discredited. You said there's additional evidence of the assault on the bus.
No, and I'll just sort of take issue a little bit with the premise there in Your Honor's question. I don't know that her credibility was she was totally discredited there. She may have, initially misrepresented the reasons for, why she got into the altercation. But again, I think the the question really is whether those materially impeaching circumstances presented to the officers at the time that they first apprehended Ms. Lin, and that's simply not the case. And so again, I think the court can easily affirm the district court by approaching this first from the probable cause for simple assault perspective. Independent of that, probable cause existed on the APO charge. I'm happy to answer any other questions the court might have. Otherwise, we will rest on our brief.
All right, thank you.
Thank you.
Okay, Ms. Dennis, we'll give you 2 minutes. Do you agree that there were 2 separate altercations? Would you concede that?
Both parties agreed in their briefing at the summary judgment stage that there were 2 incidents at least in question. However, we do not concede that there is any objective evidence beyond Ms. Rodriguez's non-credible statements that the simple assault on the bus ever occurred. The only
So you agree there was an incident as in an interaction of some sort on the bus, but we don't know that there was a physical interaction.
Exactly. There is, as my friend on the other side recognized, there is evidence, video evidence of Ms. Lin and Ms. Rodriguez both getting onto the bus, but no evidence from within the bus. The only evidence the assault on the bus even occurred, as you mentioned, was the non-credible statements from Ms. Rodriguez and her scratches. Any statements from Ms. Rodriguez, however, lost all credibility after the CCTV footage was viewed. And although we recognize that the CCTV footage did deal with the altercation outside of the ticketing office rather than inside of the bus, the CCTV footage is objective evidence that Ms. Rodriguez provided false information to the police officers about the incident in question and was no longer a credible source of information. And again, the district court impermissibly dismissed this impeaching value of the CCTV footage. In order to determine whether probable cause dissipated before that second handcuffing, the court must consider the totality of the evidence between the 2 handcuffings, and it must do so in the light most favorable to the non-moving party. Yet on reconsideration, the court failed to consider any evidence proffered by the plaintiff in the record that probable cause dissipated before the arrest for the APO. If the court had considered the evidence in the light most favorable to Ms. Lin, there would be a genuine dispute of material fact as to whether probable cause existed for any charge at the time of the second arrest. As a result, Harris does not dispose of plaintiff's 3 remaining claims relating to Ms. Lin's February 15, 2016 false arrest for APO.
Thank you. Any questions?
Thank you so much for your time.
Thank you very much for your argument. The case is submitted.
Case number 20-1453, American Clean Power Association Petitioner versus Federal Energy Regulatory Commission. Mr. Tabat for the petitioner, Mr. Kennedy for the respondent, Mr. Jones for the interveners for the respondent.
Good morning, Your Honors. May it please the court. Gabriel Tabak on behalf of petitioner. Your Honors, FERC's post-Ameren orders imposed a new rate that was fatally flawed for 3 reasons, requiring remand from this court. First, FERC clearly risked undue discrimination by vertically integrated transmission owners against competing generators, despite evidence that transmission owners still own generation in the region. FERC failed to meaningfully address this evidence and failed to square its determinations with its own precedent, rendering its orders arbitrary and capricious in violation of the Administrative Procedures Act.
Can I ask questions about that first point?
Absolutely, Your Honor.
What would the discrimination look like? And I have 2 possible kinds of discrimination in mind, and I wonder if you have one in particular that you mean when you say discrimination. One would be that transmission owners that also own a generator would kind of make a different binary decision on whether to transmission fund or whether to self-fund or whether to have a generator. That's one type of discrimination. They would make that based on whether they own the generator. The other type of discrimination would be, well, we'll run up the costs a lot when we self-fund, so long as the generator is owned by somebody else. But if the generator is owned by us, then we're going to be kind of conscious of costs, and we're going to go with the lowest bidder, so long as that kind of thing. So, are you imagining both of those types of discrimination, or just one, or a third time?
Your Honor, I believe those would be closely linked in practice, but principally the first, that transmission owners would have an incentive, or what the Ameren Court referred to as a competitive motive, to use transmission owner funding strategically against independent generators, where they might not be using it for affiliated generators, potentially driving up costs for those competitors.
They would allow the owned generators to fund, but they would not allow independent generators.
Yes, Your Honor.
What does it matter what form that preference would take, whether it would be? Does it matter whether that preference would manifest itself in version 1 or version 2 of Judge Walker's question, or it's simply the substantial risk that there would be preference in one form or another, whether they would allow generator funding or would fund it themselves because it's all the same thing if they own the generator funding it themselves, or generator funding is transmission funding.
Your Honor, I think either of the 2 circumstances that Judge Walker outlined would squarely fit within the Commission's concern with the motive for undue preference and undue discrimination from transmission owners against independent generators, as exemplified in Order 2003, which governs FERC's generator interconnection rules, upheld by this court in National Association of Regulatory Utility Commissioners versus FERC.
Yep. Can I ask, from your record evidence, what percentage of transmission owners in MISO own, directly or through affiliates, generation? Because I heard some, substantial, majority, vast majority. What's the percentage? What's the number? What's the percentage?
Your Honor, I'm not certain of the percentage off the top of my head. We're aware that the Ameren Court indicated that only one of the petitioning.
Yeah, I'm aware of that.
Yeah.
But your briefing sure sounded, like I said, at the time it got to a majority and vast majority, and so I'm kind of
a significant majority, Your Honor. We're aware of at least 27 transmission owners in the region that still own generation.
And how many total transmission owners are there?
I'm not certain of that figure off the top of my head, Your Honor.
Well, to say substantial majority, you got to know that 27 it's got to be less than 27.
A fair point, Your Honor. I don't have the figure of MISO transmission owners off the top of my head, unfortunately.
Mr. Tabak, why was that information not before the Ameren Court?
The number of...
yeah, I mean, that they concluded there was just one and it wasn't. Why was that information not before the previous panel?
Your Honor, the Commission made its pre-Ameren findings without respect to whether the transmission owners still own generation. I think that was part of the Ameren Court's basis for vacating the discriminatory treatment portion of the underlying orders from FERC. Because of that, the Commission, I don't believe, had that figure in evidence, and the Court relied upon the proportion among the petitioning transmission owners.
And since the orders that FERC issued on remand, is there any evidence of actual discrimination against independently owned generators?
Your Honor, it's impossible to know that because of FERC's practice regarding the agreements. In circumstances where a transmission owner and a generator come to terms on one of the three categories of agreement at issue here, those are filed unexecuted at the commission, those are not filed at the commission. They would not generally be available to anyone. Only in the circumstance where the generator and the transmission owner cannot come to terms would they be filed unexecuted at the commission. And we're aware of at least 18 agreements that have been filed unexecuted under protest since the Ameren decision, and at least 21 that have been filed for the retroactive 2015 to 2018 period since the Ameren decision. But the inability to determine the level of discrimination, if any, really speaks to the need to develop a record here, which is something that only the commission can do.
On the topic of one, are there 27? And of those 27, are you talking about a transmission owner that also owns a generator that is connected to MISO? Or are they just transmission owners that own a generator that's somewhere in the country, maybe not connected to MISO?
Your Honor, it's the first circumstance. Okay. They own transmission and they own generation within the MISO footprint.
These agreements that have been filed with the commission because there's disagreement between the generator and transmission owner, did any of them involve generators that were owned by that transmission owner?
Sorry, Your Honor, could you repeat that last part?
You said these filings with FERC, when there's disagreements between the generator and the transmission owner and coming to agreement for terms for the connection, did any of those involve the situation where the generator was owned by that transmission?
We are unaware of any where
So these have always been between independent generators and transmission owners that there have been disagreements.
We are unaware of any where that have been filed unexecuted between a transmission owner and its generation owning affiliate.
You're aware that at least some of them have the opposite?
Yes, Your Honor, between transmission owners and an independent generator.
You think they're all between independent generators?
To our knowledge, Your Honor.
Unsurprising.
Is a rate making challenge sort of the default method for combating undue discrimination in general?
The commission has a range of potential approaches at its disposal. A rate making challenge would certainly be one of them. And we certainly wouldn't want to presuppose precisely the form that commission action could take on remand here. But our focus is on FERC developing a sufficient record to be able to identify what the risk of undue discrimination is and balance it against any risk to the transmission owners.
So the reason I ask is if a rate making challenge is sort of the normal remedy, the default remedy that FERC makes available in the case of potential undue discrimination, then it might seem that FERC didn't need to explain why it was defaulting to the default in terms of its choice here. On the other hand, if it's not the default, if it's somewhat of an unusual remedy, then it might make sense to say, okay, FERC, if you're going to choose to allow rate making, if you're going to say rate making challenges are the remedy to combat potential undue discrimination, then you have to explain why you're choosing it.
Your Honor, you're referring to the commission leaving the door open for individualized Section 206 complaints against undue discrimination here?
Yes.
Yes. That is extremely atypical and inconsistent with the commission's approach to the relationship between transmission owners and independent generators. Again, as exemplified in Order 2003, there the commission's actions really were aimed at preventing the potential exercise of undue discrimination by transmission owning utilities. That's really where the commission's precedent is. Not to say that the commission could not adopt something different, but under the APA, the commission needs to adequately explain why, where it has not used individualized rate making challenges as a means of remedying undue discrimination in the past, it would be opting to do so here.
Mr. Taylor, what precisely did you expect FERC to do on remand after the Ameren decision, right? So Ameren, just on one level, had an economic theory that transmission owners, couldn't be forced to operate as nonprofits, right? And in light of that holding, what precisely did you expect the agency to do?
Your Honor, that's a good question, and one for which I think the most ready answer is the New York order, which this court allowed to be lodged from September, which postdates the briefing. In that order, the New York transmission owners filed at FERC to implement a nearly identical transmission owner funding practice. And I'd refer the court in particular to paragraphs 33 to 57 of that order, which detail both the transmission owners' evidence that they submitted on what they believe the level of risk to them from these network upgrades was, as well as countervailing evidence that was specifically submitted on these points from generators, from state parties, from other entities on whether they believed that these were realistic risks, and if so, what the scope of them was.
Was that not part of the voluminous record before FERC, before the 2015 orders? Was that information not part of that record?
The record prior to Ameren did not reflect the scope of any risk in any kind of quantifiable way to transmission owners. There are a lot of assertions in that record that the transmission owners face risk, but with no particularity. Again, I think the New York order stands as a substantial counterpoint to that and indicative of what the Commission is fully capable of doing upon remand.
So is your view that FERC had to create a record that demonstrated that the Ameren court's economic theory was correct?
Simply that the Commission, the Ameren decision at various points seemed to have no confidence in the level of the Commission's record on the key basis for the remand and vacature, and with instructions for things like holistically assessing the risks and benefits to transmission owners, to fully consider arguments. Looked at in its entirety, the Ameren decision simply does not seem to have expressed confidence in FERC's level of record development underlying it, which is why, in our view, the reasonable thing for the Commission to do, with some latitude for precisely how to structure it, would be to accept evidence on those core issues. Your Honors, returning to the second
I was going to ask, do you know, are there other regional transmission organizations that allow transmission funding like this?
No, Your Honor.
This would be the only one?
MISO is the exception. The New York transmission owners, again, sought it, but the Commission denied it. There is a comparable proposal that is still before the Commission from the Mid-Atlantic grid operator, PJM. That has not had final Commission action yet.
How would, in this case-by-case approach, if the agreements between transmission owners and their own generators are not getting filed with FERC, because presumably they work out any disagreements amongst themselves, how would discrimination be proved on a case-by-case basis?
Your Honor, it would be extremely challenging. From the Ameren decision and from the three orders under review here, it seems that the theory would be that if, to Judge Walker's second point from earlier, that if generators believe there were excessive costs included in their network upgrade expenses that they were being billed for, they could file a 206 and contend that the transmission owning utility was escalating costs. But as to sort of the strategic application of...
if they were escalating costs, but they were doing it to their own generators, would that be a viable claim?
If a transmission owner were escalating costs for their own generators and to the independent generators?
Yeah, 'cause I'm sure they'll say this is what we need to make a sufficient profit.
Your Honor, it might be, but we simply can't know. Again, there's simply not evidence here to show whether or not the core point that the Ameren...
Would you be able to prove discriminatory treatment? Just that, put aside excess costs. How would you be able to show discriminatory treatment?
In a context where only a 206 complaint is available? Mm-hmm. It would likely have to be under the excessive cost, or if there were additional sources, for instance, state regulatory filings that showed differential upgrade costs for affiliated generation. Those would not be before FERC, but it's possible that depending on what state commission rules require, there might be evidence available. That would vary significantly state by
Do the
state.
states covered by MISO require such filings? I mean, have you looked to see if there's this is actually happening?
Yeah, there's wide variation in what the level of detail before state commissions might be, Your Honor. But it is certainly not the case that there would be a readily available information in all states in MISO that a independent generator would be able to ascertain if they had been subject to undue discrimination where a transmission owning utility had escalated costs to them, but not their own affiliated generation.
I had one other question too, that do you dispute that whatever the rule you think FERC should adopt, yes or no, on transmission funding, that the rule should be the same for direct and indirect connections? Do you dispute that aspect of their reasoning?
Your Honor, I think that needs to be broken into two parts, prospectively and retroactively.
I'm sorry, yeah, I meant prospectively.
Prospectively, the Commission, if the record demonstrates comparability between the parties who are subject to those three types of agreements, that could be a reasonable approach. Comparability is simply presumed, and the order in which FERC determined.
Well, how would they not be comparable?
Your Honor, they very likely would be, but I think that would have, the ultimate determination would have to wait for a Commission determination of that.
Well, I'm just, do you have a theory on how they wouldn't, in the two situations wouldn't be comparable? Possibly?
Your Honor,
I don't have enough experience in this area to be able to understand why there would be any differential treatment prospectively.
There could be differential treatment based both on aspects like the multi-party facility construction agreement that have multiple funders for them. There could also be differences in the type of facility being funded. For instance, the Ameren Court noted that in the region for upgrades above 345 kilovolts, 90% is funded by the generator, 10% is passed through in transmission rates, and a rate of return is recovered on that 10%. So it's possible there could be variation by both agreement type and upgrade type. But again, those are fact-specific matters that we can't know until there's a record on those points.
If I could share a theory of the case that you won't like, then ask you why it's wrong. I'm going to share a different theory of the case with FERC and ask them that they won't like and ask them why it's wrong. Here's the theory I want you to tell me why it's wrong. We start with what you and Judge Millett were just discussing, that, FERC before Ameren decided the indirect and the direct transmission owners had to be treated the same. And that wasn't disturbed by Ameren. And as I see it, that may even be sort of a case closed, a done deal issue. And so then the question becomes, well, is FERC going to level up by allowing both direct and indirect transmission owners to self-fund, or is it going to level down by not allowing either of them to do it? They tried leveling down, and Ameren said that one of the problems with that is enterprise risk. And Ameren didn't leave a lot of room for FERC to later say, well, we don't think enterprise risk is a real risk. I think Ameren made pretty clear that it's real. And so to the extent that you're going to level down, it's because you have to have a different reason that is more important, that outweighs the enterprise risk. And the most logical different reason would be this potential for discrimination. And so then that raises the question, well, is there evidence of discrimination in the record? Seems like there's not evidence in our record of discrimination, because Ameren said there wasn't evidence in the record and there hasn't been any more record. And then Ameren said there could be an economic theory for potential discrimination. We're not going to give a lot of weight to that because there's only one petitioner who owns a generator. But we now know that there are 27 or something. And so then your case against FERC has to depend on saying why FERC was wrong in that situation to say the remedy for that potential discrimination is individualized rate-making challenges. And FERC said that's the remedy, and they didn't give a lot of explanation, but they gave enough explanation. And They do this in other contexts. So it was a reasonable remedy to choose, and it was reasonably explained. So what's wrong with that theory of the case?
Your Honor, 2 points on that. The first is that on the initial part of that theory of the case, you mentioned the comparability determination from FERC. That was in an order that was itself vacated by Ameren. So I think that issue is remains open for a future evidentiary demonstration through a commission proceeding. The second point regarding the risk of undue discrimination, the Ameren court quite clearly left the door open based on the competitive motive that transmission owners still owning generation would have. Petitioner proffered that evidence. The commission notionally accepted it at paragraph 38 of the second of the three orders, the order on briefing and rehearing here. But to call that cursory treatment, I think would be generous there. That is the precise animating rationale that this court acknowledged could pose a risk of undue discrimination. And again, that risk of undue discrimination, the potential for competitive motive, is precisely what the commission has used to justify, and this court has upheld in prior rulemakings and proceedings between transmission owners and generation. So at a minimum, the commission needed to better explain why it found that evidence unconvincing, and why the remedy that it adopted there of individualized determinations was consistent, or why it had changed its mind from those past determinations, again, upheld by this court.
If we were to say exactly that in remand, would that get you pretty much what you want from us in this case?
Yes, Your Honor. We would submit that on a remand to FERC, the commission would of course have some latitude about exactly how to structure it, but we would fully anticipate that they would develop the record in a way comparable to the New York order that's lodged here, that holistically looks, as the Ameren court put it, at the risks and benefits to transmission owners, that considers the potential undue discrimination for independent generators, and considers those things through development of substantial evidence, which was the second of the 3 points I was going to lay out at the outset.
A long time ago.
Yes, but development of substantial evidence to fully support ultimate orders here that considers all of these aspects, rather than a cursory reversal without further record development, which is what occurred here.
Thank you very much.
Thank you, Your Honors.
I think we'll hear from FERC now.
Your Honors, Robert Kennedy on behalf of the Commission. Judge Walker, picking up on your question, Part A, whether or not the distinction between generator direct connections and interconnection agreements, whether they are similarly situated. In response to that, Council indicated that the Commission's determination was vacated, which it's true. That was initially made in the underlying orders. In footnote 77 of the remand order, the Commission noted that, reaffirmed its determinations. And I would agree with you. I think the idea that there's any distinction as to how indirectly connected generators should be treated versus directly connected generators is a done deal.
I agree with you on that. But I have to say I'm pretty sympathetic to the second thing he said in response to my very long-winded question. So if you could address what I think is his strongest point, which is the decision to allow rate-making challenges to be the remedy for potential discrimination, was unexplained.
Well, I think certainly the Commission flagged that as, first of all, if I can step back, and I don't mean to sidestep your question, but I will get there. But I think it's important to understand the context in which this took place. The entire case was started by the Commission in its sua sponte investigation. So the Commission took on for itself the burden of establishing that the existing just and reasonable rate, transmission owner funding, the option for them to unilaterally choose that, was unjust and unreasonable. And then the second part, the Commission had to establish that a replacement rate was just and reasonable. And the replacement rate is the unilateral selection by the generators as to self-funding. The commission didn't, and that was vacated by the Ameren court. So the question before the commission was, A, based on the entirety of the record, can we, and in taking into account the infirmities flagged by the Ameren court, can we make a renewed finding that transmission owner funding is unjust and unreasonable? And if so, then can we go on and establish a just and reasonable replacement rate, the absence of it, giving the generator the individualized choice, the unilateral choice. In answering part one, could the commission establish that transmission owner funding was unjust and unreasonable? Not that it is just and unreasonable, that it is unjust and unreasonable. A little difference in the burden of proof there. The commission made two findings. One, compensation, which I'll come back to, and the second was discrimination, getting back to your question. Again, there was no evidence of actual discrimination in the record. The record has been open since 2005. There has never been any showing. Had there been, the commission obviously would have been interested. It would have bolstered its initial finding. Second, as to an economic theory for discrimination, the Ameren court noted and the commission accepted that there really is no economic theory supporting the potential for discrimination as to those generators, as those transmission owners that are not, affiliated with generators. As to the third, the commission accepted their proffer that, and I don't know the numbers, Judge Millett, but the orders say a majority of the transmission owners in the Midwest are affiliated with generators. It accepted that, but found that that did not make the existing transmission, and accepted that there would be an economic motive for them to discriminate. It's not evident, there hadn't, again, if this has been in place a while, there was no evidence that had been used in that manner. So the question before the commission, okay, does that make the existing transmission owner funding option unjust and unreasonable? Now, obviously, this is all made against the backdrop of the Ameren court's decision that the commission's previous remedy was constitutionally and statutorily on shaky ground, to say the least. But the commission said, okay, we have the normal process for this. When there's disputes regarding interconnection agreements, there's a process that can be ironed out. Claims of discrimination can be raised in there. You'll see in these orders, the commission said, if transmission owners are treating their affiliates one way in terms of not making them fund or vice versa, treating their affiliates different, making different choices.
How are they going to show that?
Excuse me?
How are they going to show that?
Well, so, and my initial point with respect to all your questions about the adequacy of the remedy, the commission flagged it at its remedy, and there was no dispute raised, there was no questions raised as to its adequacy.
FERC's the expert here, claims to be the expert agency. How did FERC, in making this choice,
correct,
think they were going to show actual discrimination if the agreements between owned or affiliated generators and transmission owners, there's no disagreement, and so they aren't filed with FERC? How are they going to show it?
So the commission hasn't, in these orders, worked out, it didn't want to prejudge those issues, it said in here.
Prejudge, it said this is a remedy. How can you think something's a remedy if you don't have a conception of how it might work to show discrimination?
Well, correct. The way these normally work is the party comes in and says, I'm being overcharged, there's a dispute as to the agreement. You bring a complaint, you make a prima facie case saying, I'm overcharged, I have some other issue, and then there's a process, there's discovery involved, and all that, in which
does discovery get into whether they're overcharging their in other agreements? I
think in this context, given what the commission held in these orders, that if there is differing treatment, that would have to be explained by the.
No. I'm going to back up. You're saying what would happen if they showed differing treatment. I'm asking a predicate question. They come in.
Sorry, go ahead.
If you were answering it, go ahead and finish.
So I think
there is differing treatment. I'm trying to get to that question.
The commission flagged in these orders again that if that transmission owners need to treat their affiliates and their need to have a valid reason if they're going to treat them differently. Why? So I think that is a live issue that could be raised in these complaint proceedings that the commission established.
How are they going to? Sorry, I'm not being clear somehow here. All right. I am an independent generator, and I think this is way too big a bill, charging for too much stuff. I file a complaint with FERC. Now, I would like to, I suspect they're not charging their own generators. They own, the same transmission owner isn't charging their own generator that type of extra costs. How do they show that?
Well, I'm suggesting that if there is a prima facie case being made in the complaint, that
prima facie case of what?
That they are being overcharged. Or treated unfairly,
Those are two different things. I mean,
they are being
overcharged because they don't know if it's unfair.
Correct. That they're being overcharged. That there is discovery that takes place in there, and I think given
and discovery of what
of the cost, you can try and prove that it is being overcharged. So I think.
But would that I'm going to try again. Would that discovery include generator or transmission owner? Did you impose these same costs on generator X, which happens to be affiliated with you? Do you get to look at other agreements as part of that discovery process?
And my bottom line answer is I can't answer that definitively. There is a discovery process, and because
if FERC didn't think that they would be able to show, if FERC had no conception of how they would be able to make this showing of differential treatment, how could it possibly have thought this was a remedy? Didn't it need to explain how this would work, how it would address discriminatory treatment?
I'm saying the record here does not reflect what would happen in the discovery process. I'm suggesting the commission has identified in here that if there is differing treatment, that is something that needs to be explained. So it could be a valid basis for discovery.
I don't have
maybe one way of answering Judge Millett's question. What's happened with the 18 or 20 unexecuted contracts that have been filed?
So I think what that is.
I mean, is there any? What happens in that case?
I'm not sure I know the answer to that, where those stand. I think that number captures the number of agreements entered into during the interim period that then the transmission owner came back and said, I would like to take advantage of the opportunity to self-fund these upgrades. So I don't know if there are I'm unaware of what the status.
So those aren't necessarily contracts in which there's an allegation of discrimination.
That's my understanding, and I think it's 21. That's what I think that number is, and you see that in the end of the second rehearing order. In this case, those are out of the universe of roughly 100 agreements entered into while this proceeding was going on. There's about 21 that a change in the funding mechanism was made.
But this, as you said, look, this is our usual. We do this all the time. People can always come file complaints on a case-by-case basis about rates charged. They can always do that. This is not a novel process created for this problem. So there must be rules about what this discovery, we have rules on what discovery what comes in and what doesn't. And so do non-filed agreements between other generators and that transmission owner. Is that relevant discovery? Or is that something that's confidential and isn't going to come in?
Well, again, because the record in this case does not reflect that. And there have been no, I understand your frustration. And I think it stems from this.
I'm aware the record doesn't reflect it.
There has been no allegations of discrimination. The issue has not been litigated. So I'm not sure.
They can't figure out how to
for discovery. What's the standard for discovery?
Well, I think it has to be relevant to your allegations. It's not. I apologize. Not my
Judge Millett's hypothetical seems like that information would be relevant.
It could. Yeah.
Well, is it relevant if they have to make they've made a prima facie case that they've been charged a lot of high costs. They haven't made a prima facie case that it's because of discrimination. Do we just infer when there's high costs that it's discriminatory?
No,
we don't do that. So what prima facie case does this person who thinks they've been, this generator thinks they've been charged too much, how do they get even a prima facie case so that it will be relevant for discovery purposes of discrimination?
Again, because this issue has not been litigated, I can't answer your question.
All right, but we can all agree then that FERC did not explain how a prima facie case of discrimination would be made on a case-by-case basis.
I agree that the commission identified this as its preferred remedy.
Are there other FERC orders
and there was no issues raised with it that the commission had the opportunity to.
Are there other situations where FERC has said we see the structural problem? You said FERC said a majority of transmission owners also own generation. We know at least 27. That's more than the one that was at issue in Ameren. We see the structural problem. We've recognized that as a structural problem for years and years and years. Is there another situation where they've said, let's solve that case by case?
Nothing immediately comes to mind, Your Honor.
No,
but again, I mean,
a structural problem before.
There's a theoretical problem. That's what the commission acknowledged here. Again,
Original sort of significant orders on this thought it was just theory.
Sorry, I missed it.
The whole reason that there was all this impetus to try to stop, I think what then Judge Roberts called the bad old days of vertical integration. That wasn't theory. That was a real problem that FERC has been trying to get rid of.
Absolutely.
For quite some time. So that's not theory. That's not economic theory. That is the problem that FERC has been trying to eliminate through orders. And so now you have an order that says, we accept that, I'm told 27, or FERC will go with FERC's own answer, a majority of these transmission owners own their own generation. We're taking that as given. And we don't know if that's a problem or not. You come prove it on a case-by-case basis. And you say you're not aware of them ever having done something like that before when they have. In Ameren, they didn't have the evidence. And Judge Silberman was quite clear, the court was quite clear in that opinion, and Judge Silberman was quite explicit at oral argument. It would be a totally different case if they had that evidence. And so here FERC has it. But now it seems to be walking away from what it's been doing for years and years and years and years and trying to eliminate vertical integration.
Well, so my answer is the Ameren court also made clear that the commission's, the remedy it initially chose was statutorily and constitutionally infirm.
If there wasn't, because there wasn't a discrimination problem to be remedied.
I believe the court said even if there was a theory supporting discrimination, then the commission would still have to answer the second question. Again, remember, it's a two-step process. Is the existing universe unjust and unreasonable? If yes, then okay, what can we do about it? And the court found that there were significant concerns with the commission.
Where did FERC say here that it couldn't do anything about that discrimination? The only thing it could do was resort to this.
Well, the commission did walk through it and retract it and explain why its previous findings as to why.
All it did was say what the Ameren court said.
Well, it went beyond that, Your Honor. It found one of the points by the Ameren court was that, and again, this sort of goes to both sides of the equation, whether the existing rate is just and reasonable and what a replacement should be, but that the commission had never really grappled with the transmission owner's position that operation of these network upgrades subjects them to risks which are not compensated under the current tariff scheme. Commission, the court said, kind of the commission, you sort of dodge that issue, go back, take a look at the record and address it. And the commission did. It accepted the transmission owner's proffer that operation of these does subject them to a variety of risks that are not compensated under the current tariff regime.
So option C might be let them compensate for those risks in the tariff.
Which transmission owner funding does, because then they get to be able to put it in.
But it does more than that. That's the problem. It's that FERC never considered an option C, which would be generator funding, but the tariff has to allow compensation for those risks.
I mean, certainly there could be other ways.
Didn't consider any other options.
Well, because the question before the commission was, based on the record, could it reaffirm its finding that transmission owner funding is the initial hurdle it needs to clear, that it is unjust and unreasonable. And because there were uncompensated risks, the commission found that it was reasonable that generators should.
Where did they explain it was those risks were so substantial? Where did it give an explanation as opposed to just state it in a conclusory form? That those risks were so substantial, they outweigh this imperative that has sort of driven FERC for, as I've said, years and years and years of policing, being suspicious about, and trying to eliminate vertical integration. Where do they say make that balance?
Well, I think as you walk, it clearly does not use the language you just used, but it walks through its findings.
Tell me where you think it makes that balance.
So I think if you look,
which order two are we talking? Because we had.
I'm sorry, I lost the last end of your.
We had a lot of orders here, so tell me which order first, and then which page.
I guess I'll start with what we call the remand order, around page 225 of the JA, paragraphs 38 and 39.
Oh, hang on, that's not this.
I'm sorry.
My thing's breaking right now.
I'm in the that's. We could start there if you like, but I'm sorry if I could redirect the court's attention to the remand order, which is actually at I'm looking at pages 156 and 157 of the JA.
Okay. So tell me where they made that balance between the two.
So I think if you look at paragraph 31 of the remand order, the commit, which is JA 157, the commission finds that there are, based on the record, there are uncompensated risks that transmission owners are subjected to through operation of these network upgrades, and that they shouldn't be. That is essentially in part 2 of that sentence there. Basically says that it's reasonable that they should be afforded an opportunity to be compensated for those risks.
Where does it say this harm is so much that it outbalances what we have long recognized to be a discrimination problem? It's that balance. You're saying they had to balance. There was 2 things going on here, and I don't see that. Okay, we see there's a problem. Ameren told us there's a problem. Our record doesn't rebut that problem.
Well, then I think,
and that problem outweighs the risk of discrimination.
And then I think you go to the remand rehearing order, paragraph 38, where again it talks about, here we are. We do.
Wait, sorry, I gotta find what page.
That's page 225 of the joint appendix, paragraph 38, which is the remand rehearing order.
Well, that's just again, that's just conclusory, right? I mean, if I were describing their decision, I would say they decided that there isn't enough. Let's see, is not itself to demonstrate there is undue discrimination.
Correct, and then it identifies it identifies the remedy there, and then on the next page again, on paragraph 39, it reiterates the point that there's not enough evidence in the record to overcome the transmission owners showing that they do take on risks when they operate those.
Describing what Ameren said. It's not making an expert judgment.
I'm sorry, Your
39 is just describing what Ameren said.
Well, and then I believe the penultimate.
I mean, the court remanded for a reason because it wasn't making the decision, and it thought the expert agency here, who is the expert on this risk of undue discrimination, is absolutely the expert and has the ability to see, well, how big is this risk of uncompensated costs? And then balance those 2 interests, and it didn't do that. I mean, it could, maybe, the question, I'm not here to say what the right answer is. It's to say that was in picking this case-by-case so-called solution or remedy that no one seems to know how it's actually going to work. And FERC didn't grapple with that. As a solution here, as opposed to considering any other options, or just explaining why we're no longer concerned about majority ownership problem here and its discrimination, which Ameren was very careful to say, we're not dealing with that situation.
Correct, but I believe the commission's analysis here is that it could not carry its burden of showing that transmission owner funding is unjust and unreasonable because A, there are uncompensated risks there, and B, yes, there is a potential for discrimination with respect to.
Is there a dollar value anywhere on those uncompensated risks? Like what percent? I mean, if they have uncompensated risks and it's, a material percentage in a way that's going to affect their profits, their attractiveness to investors, that's one thing. If at the end of the day it turns out to be, a penny on $1,000, then the balance would be different. Did FERC anywhere sort of see what the magnitude of that uncompensated risk is?
I don't believe the record here reflects that. I will sort of take issue with your point that maybe it's a different question if it's going to throw them into bankruptcy. That's really
I didn't say throw them into bankruptcy. I said material in a way that would affect their profitability or their attractiveness to investors, which is what Ameren was concerned about.
That's sort of a step 2 question in, would eliminating it be just and reasonable? But here the commission again found that the record didn't support the first part of the 206 analysis.
But you would agree that if there was a problem of undue discrimination and transmission owners came in and said, well, we weren't able to collect a penny last year. We missed a penny. It would be quite unreasonable for FERC to say, okay, let's not worry about that discrimination. You need your penny. right? Now, I'm sure they're going to say it was more than a penny, but what I'm asking is, to make this judgment about whether this remedy is the way, is just and reasonable. This case-by-case remedy for discrimination is just and reasonable because of this other harm. Don't we need to know what that harm, not just words for it, but like some sense of how material that harm is, how significant it is? Does it really have an impact on profitability or investment?
Well, again, I think the statutory context and the standard and sort of what was happening here matters. The existing rate was transmission owner funding. That was the existing just and reasonable rate.
So FERC's not capable of thinking of anything else.
I'm sorry?
FERC is not capable of saying transmission owner funding is fine as long as something to protect against discrimination, or transmission funding is out, but generating funding is fine as long as uncompensated costs, the tariff allows for incorporation of these costs and risks into that. FERC can't do that?
Only if it first establishes under Section 206 of the Federal Power Act that the existing rate is unjust and unreasonable. Mm-hmm. Only then can it get to the second step. Mm-hmm. And again, the commission here.
So in this two-step process here, they could have said unjust and unreasonable because of discrimination concerns that were not before the court in Ameren, but were specifically reserved and acknowledged that could change everything. So that's it's unjust and unreasonable for that reason, but we're not going to go just going with generation funding. That would not be just and reasonable either because of these if they were material in any way, these unaddressed costs.
Yeah, I mean, certainly if the commission.
They can't make you need your generator funding tariff has to allow for addressing these costs. They can't do that?
If the commission found that the record supported a conclusion that the existing tariff was unjust and unreasonable, yes, it has sort of broad remedial authority under step 2 of the analysis, again, bound by its statutory authority and
Mr.
Constitution.
Kennedy, why did FERC have to decide whether the transmission owner funding was unjust and unreasonable? I mean, what is the commission's view about the intervener's argument that this is a Heckler v. Cheney type of situation?
I'm sorry, I lost the end of your question.
That this circumstance where you have a remand and the court has vacated all of your orders, including the order to sua sponte consider whether transmission owner funding was just and reasonable. Did the commission have to go back and make any determination?
No, again, this started back in 2015 as a transmission owner coming to the commission and saying it's unjust and unreasonable that bringing a complaint to the commission saying if this generator was directly connecting to me, I would have the option to self-fund, and the commission took it, and it should be extended everywhere.
Right, and then the commission sua sponte considers the question as a whole.
So following Ameren, what's the state of play? The state of play is that the commission's changed to the existing status quo, which was transmission owner funding in the generator interconnection agreements, but not in the indirectly connected agreements. That was the status quo. So then if the commission wanted to change that, wanted to take it on, it again, as I've been sort of trying to explain today.
Well, it had to do that. It had to deal with the indirect connection issue, the otter tail issue. They couldn't have just
Sorry, Your Honor, I'm having...
They couldn't have just sort of said, never mind, we're dismissing our complaint. They had to deal with otter tail's complaint.
Correct. And then the commission...
So they had to do something. They had to pick one solution or the other because I think, at least as a prospective matter, no one's complained. No, I haven't heard people saying it was unreasonable for FERC to equalize the treatment of direct and indirect connections. And so then they had to pick, right? This wasn't like we're just dismissing our complaint and going away. They had to deal with this otter tail objection and come up with a solution to it.
Correct. When the orders on the commission's, yes, that's what's left. The commission took it on itself to extend transmission owner funding. To take away transmission owner funding, to change the status quo. When the orders were vacated, the pre-existing status quo was transmission owner funding in the direct connections and in the indirect. Yes, you had otter tail's complaint that should be equalized. The commission relied on it or reaffirmed its previous finding that all those parties, whether directly or indirectly connected, are similarly situated, and that the pre-existing just and reasonable rate should be extended to those indirectly connected agreements.
And I know we're
No, go ahead.
My first question was, where is FERC's explanation for why it believed case-by-case challenges were adequate? What's the answer?
Well, I think in the remand order,
you pointed us.
Again, I think
I not only read what you pointed us to, but I wasn't surprised that you named those JA pages. Those are the JA pages that I've got scribbled all over in my notes before oral argument. And I think the closest FERC comes, I'll give you a chance to tell me why I'm wrong, is paragraph 38 on JA 225. And the last sentence there, it says that a WEA, I'm going to skip ahead a bit, does not show why the ability of interconnection customers to challenge costs before the commission is inadequate. Fair enough. Maybe the WEA did not show why that's inadequate. But I think FERC had to show why it was adequate. And where is FERC's explanation for why it was adequate?
Well, I think in the Ameren decision itself, the court flagged this as one avenue to.
But would you agree that if I read Ameren for the fifth time, which I've read,
I mean, just a short circuit. And
if I read Ameren and I don't find what you just said, do we remand?
The court. I'm sorry. We kind of just said the lot. Do you need to remand? No, because I think again, this goes to the first part of the analysis. Did the commission was the commission reasonable in concluding that the existing setup was unjust and unreasonable? And there's sort of two bases there, and I think they're independent. That one, there's uncompensated risk, and therefore it's reasonable to offer them some degree of compensation. And again, the idea that the commission has not expounded on how this will work out in practice, it's sort of reserved the issue. If you look in these orders, because the same issue came up with respect to how we're going to treat the interim agreements. The commission said it would take a case by case. Didn't want to prejudge the issue and would take a case by case approach to how we would deal with that.
Great.
Great. Thank you.
As far as any further questions, thank you, Your Honors.
We have an intervener now. Thank you.
Morning, may it please the court. Christopher Jones for the interveners. Judge Millett, I'd like to start, if I could, with the case-by-case issue, because there's I think there's a fundamental misunderstanding presented by the petitioner's argument. I think petitioner actually said they can't know if there's been discrimination. That is absolutely not true. This whole scheme is part of the most transparent regulatory regime that the industry has frankly ever seen. And over the 15-year history of transmission owner optionality, the reason that there has not been a single allegation of undue discrimination, but the reason they can find out.
Is there history of this in any other regional transmission organizations?
Your Honor, I think counsel was correct that that other RTOs have moved off in different directions. So the transmission owner funding was originally developed by the commission in its pro forma order 2003. It remains in the Mid-Continent just by virtue of the way that the Mid-Continent tariff has developed.
And then can I ask you I'm sorry, I just wanted to get to the chase because time is short. This discovery issue that we were talking about which I confess profound ignorance about how it works before FERC. So if an independent generator comes in and says, I think I've been overcharged in a way that makes the rates unjust and unreasonable, FERC. And does that allow them to get discovery of the agreements not filed with FERC between that same transmission owner and, say, generation that it owns?
Absolutely, Your Honor. These contracts are not secret contracts.
They're not filed with FERC. Where are they filed?
I want to be clear about this. The only reason that the contracts that are agreed upon are not filed with the commission is only because they use a pro forma form, and the commission, for workload purposes, says if you use the form contract, I don't need to see it. That's the only reason those contracts are not filed with the commission. In fact, now I can't say this with
so where would I find?
So there's two places. I can't say I haven't checked in recent weeks, but at one point every contract was actually available on the MISO website. Again, Mid-Continent itself is a party to these contracts. They sign them. The second place is.
And those form contracts, will they detail the charges Because my assumption is that the independent generator doesn't have a form contract. It's getting charged more. Will it allow you to document whether owned generation and this independent generation are charged the same things? Can you tell that by looking at the
as to the funding election, that has to be memorialized in the agreement. It's apparent on the face of the agreement.
All these costs.
Well, the costs, indeed, yes, the upgrade costs are absolutely in there as well. The costs for building the new line, for building the new substation, they are
every piece of evidence they would need to know whether they were treated exactly the same as a transmission owned generation. Every detail of that contract, every number is going to be there on MISO's website, just like theirs.
Again, I don't, at one time they were on the MISO website. Again, the second, I don't know if they still are. I don't run the MISO website. The second place, though, Your Honor, is the commission, in lieu of requiring them to be filed, asks for this thing called an electronic quarterly report, at which point every contract is listed and the parties there too. Again,
listing contracts and parties isn't the same thing as the details in a way that would let me know if I was treated differently or the same.
I don't believe the petitioners have ever asked. And
that's not my question. It's whether the information, I at least was concerned, if you're going to have a case-by-case approach, it's got to allow them to show discrimination. And it wasn't clear to me that this discovery process would allow that.
And again, I would suggest that it doesn't even need to get to a formalized discovery process. Again, with an independent entity running the transmission system and signing these agreements, our funding elections are not secrets. That is just not true, that they cannot know. And again, I think the only reason there hasn't been record developed there is because I have not been made aware of these things.
When you say funding election, you mean transmission funding versus generation funding?
Yes, Your Honor.
No, but that's not, the point is the details of it, like what they're charged.
As to, is your question, Your Honor, did we just simply charge them more for the same widget?
That, yes, or a higher rate of return, or, I mean, there's a lot of ways and a lot of numbers that a transmission owner could, up things for, I'm not saying this is happening, to be clear. This is all hypothetical.
To be clear, and let me unpack those in the order which you presented, in backwards, actually. The rate of return absolutely cannot be changed. That's regulated by the commission. It's in the tariff. We have no ability to change that or charge different rates of return to different customers. Would not be allowed. That's the filed rate doctrine would prohibit it. As to other costs in the agreement, those are costs flowed through on an actual cost basis detailed in the agreement itself. So a typical generator interconnection agreement will say $10 million for a new substation, $5 million for a reconductor of this line, and $5 million for some other labor associated with doing the project. Again, the reason, and you're right, at some point this entire regulatory regime was grown out of a suspicion of vertical integration. I would grant you that. But what we have in its place is an independent entity and a pro forma contract that makes these details available. I don't.
It's too bad FERC didn't say what you've been saying.
Your Honor, I think maybe the reason they didn't is because frankly, it's so ingrained in the regulatory regime that this is the transparency of it, and that these contracts are not state secrets. In fact, we would expect to own our cost estimates and expect to own our funding elections at every turn.
Well, if it's also transparent, then why would there even be a need for this case-by-case ones? Everyone.
Well, again, if it's
all set, if the rates returns, if all these charges are out there and they can't be changed between different generators,
But what Petitioner is worried about is the funding election, and we do have that optionality. But that optionality has been in the.
I don't think they're worried about the funding election.
Years.
I think they're worried about what's going to happen with the funding election.
I'm sorry, Your Honor, I missed the question.
I think they're worried, they're not worried just that you pick transmission funding in the abstract. It's what transmission funding allows to have happen. That's what they seem to be worried about.
It is, and it would allow us to earn that regulated rate of return, which we cannot change. That rate is in the tariff.
Mr. Jones, is part of your argument that because there is so much transparency, there is in fact not a lot of discrimination because everyone can kind of see what is happening in these contracts? I mean, do you think the transparency in part eliminates the possibility of discrimination or eliminates the actual, any possibility of actual discrimination?
Your Honor, I don't know that I would go so far as to say that mere transparency would per se eliminate all possibilities, but it would absolutely bring it to light were it to occur. Absolutely. I mean, again, the vertically integrated utilities operate under a comprehensive scheme of regulation to ensure exactly that the transmission system cannot be used to provide preferential access to an affiliate or a cell phone generator or transmission customer. That's the entire regulatory regime that's been in place now since 1996. So when we say
your decision in Ameren said the reason it wouldn't reason that the reason that there would not be discrimination risk is that there was only evidence of one, and then specifically went on to say because this has all been getting this vertical integration has all been getting driven out by FERC and its orders. We did not say anything about it won't happen because of transparency. Well, it can't happen, or it will be such a minuscule risk. And this is all the balancing that normally I would have thought FERC would do. They would say because of this transparency, because of this, because of that, maybe it could happen, but it's hard. Even if you have 27 of these folks owning their own generators, it's just really hard to discriminate these days because of other protections we've put in place. And the costs and risks that are not being compensated are high enough to make this, that balance, that's what, that we need to worry more about that than we do about discrimination. But I just don't see that anywhere in FERC's decision.
Well, I think the Ameren Court's discussion of vertical integration went to motive. And what the commission did on remand said, we looked and again see no record of a single allegation over a 15-year history of transmission owner optionality in funding that this has ever happened.
Well, that's because for a while there was a third option that was being used. First of all,
right.
We don't have a peer record.
Yes.
But again, it's the question here is FERC needed to explain why with these two concerns. And when Ameren was on a record that didn't have really a plausible discrimination concern. And then they say we accept the association's evidence that in fact there are a majority of integrated, vertically integrated transmission owners. We're accepting that now. So now we have a problem that we didn't have in Ameren. And then said, we accept that there's uncompensated costs and risks, or maybe it was just ended up being uncompensated risks, but it didn't quantify those. And it never did this balancing, which it's the expert. It could get this information and strike the balance as it seems reasonable.
But I think the reasonableness of FERC's reaction in that situation, Your Honor, goes from the fact that this rate has been in place, like I said, for 15 years, and the commission has known that there's been no generator has ever stepped forth and said, I am being treated unfairly as to the funding election, or there may have been cost disputes, but those can be handled. I don't know that there was ever a discrimination cost dispute. But again, the commission, I think, was absolutely reasonable to say, the court told us we overstated the risk of discrimination, we understated the risk to the transmission owners, and we look back on the record and we think that the court had it right, that we got that balance wrong.
Okay, thank you very much. All right, we'll give Mr. Tabak, we'll give you 2 minutes. If you can start by responding to this argument about can't have discrimination with all the transparency that's out there. So what are you guys really worried about?
Thank you, Your Honor. On that point regarding the potential for discrimination and transparency, we note that the core issue here is that while MISO is an independent administrator of these contracts, the election is unilaterally done. The election of which funding structure to use is done by the transmission owning utility at their sole discretion. MISO can reflect that. MISO will collect the associated rate, but that is not the decision of the independent grid operator.
The decision. Go ahead. Getting back to your first question, I think.
That was true before. So why should FERC have kind of believed there would be discrimination once you also allowed self-funding by indirect?
Your Honor, 2 responses there. First, The Otter Tail complaint dealt with one category of the affected transmission owners, the facility construction agreements. It did not deal with the multi-party facility construction agreements, which is a separate category, and that sort of leads to the retroactivity to 2015 for that category that wasn't on notice.
I think I'm asking a different question.
Yeah, I think so, Your Honor.
Just before whatever year it was filed, 2000, what year was Otter Tail?
2015.
2015. Before 2015, direct transmission owners could elect to self-fund. There's no evidence that they were discriminated. And maybe it's because of this transparency motive, incentive to not discriminate. Who knows why? But they weren't discriminating before 2015. And so now that we add a new group that can also do what direct transmission owners were doing, why would we think that all of a sudden, why would we think the indirect transmission owners are going to discriminate when the direct transmission owners never discriminate?
Your Honor, I would simply say that factor, if it was animating FERC's decision making, is not reflected there. They did not.
And I'm pretty I think I agree with you, and that's probably the case. But what's your answer to the question?
Your Honor, our response there is that the structural motive that the Ameren Court noted is still present, and the Commission's response to structural motives has been to structure prophylactic rules that prevent the potential exercise of undue discrimination by transmission owning affiliates. Again, if the Commission changes its mind, it needs to adequately explain why the new remedy it's proposing is sufficient.
Mr. Tabak, you've also asked us not just to remand for further reasons, but also to vacate FERC's decision. I mean, what will happen to all the contracts that have been entered into in the interim?
Your Honor, for the contracts that have been filed unexecuted, I would imagine that the Commission will have to revisit those. Those, I believe, are treated as open proceedings at the Commission, and there may be an opportunity to move away from the funding election. For the contracts for which the parties reached agreement and they were not filed unexecuted, my suspicion is that those would not be reopened because the parties had a meeting of the minds. But ultimately, whether there needed to be some remedial effect here because all of FERC's actions were immediately timely sought rehearing and timely appealed. If there's constructive notice back to that date, then FERC may be in the position, depending on what the record reflects, of having to consider retroactive application back to 2018 or back to the interim period.
Do you agree with the predicate of Judge Walker's question that there was no discrimination by direct transmission owners that directly own their own generation prior to 2015?
I would agree that the Commission did not deal with any complaint on that front. And my understanding is that transmission owner funding was little used prior to that period.
Oh, so, okay. So it wasn't used often, so we don't really know then. There wasn't sort of a statistically significant sample before 2015. Is that your answer?
I think that's accurate, Your Honor.
And now it would be pretty universally used within MISO? Is that the point?
Our understanding is it has become prevalent in the region, and this speaks again to the indicative precedent here is what I would believe led to the New York transmission owners filing for comparable treatment here and in the September order that's lodged with the court.
It's such a great gig that everybody's doing it now. Why weren't they doing it before, the direct transmission?
Your Honor, I can't speak to the decision-making process at that time. I mean, there could be various factors that play in here, including the type and value of the network upgrades that might be at issue, which again speaks to the need for record development here to establish both what the risk of undue discrimination might be and what the risk, if any, to the transmission owners is, and to holistically assess those risks and benefits simultaneously and arrived at a reasoned conclusion that balances them.
If we remand and FERC comes to the same conclusion in their explanation, everything Mr. Jones said,
Honor, if FERC does the type of record development that it did in New York and adequately explains itself, I think that would be a very different case from the one before the court today. I can't presuppose any action from independent generators at that stage, but it would look like a fundamentally different case from the one the court's considering now.
Right. Thank you very much.
Thank you, Your Honors.
Are all the attorneys? And the case is submitted.